I'm Heather Scott from District 2, and today before you is RS 33038. I'm asking for a print hearing, and this is dealing with child custody interference and enforcement of court orders and parenting time. Last summer, I was part of a child custody and domestic relations task force that traveled across the state to hear from citizens, judges, lawyers, law enforcement officers, and assistance groups so that we could dig deeper into the issue involving children in family courts and custody battles. What we learned was frankly heartbreaking, but we did learn there's specific reoccurring problems that surface through these meetings. One of the largest problems that we kept hearing over and over had to do with custody interference and how it was being implemented in our state law. We heard multiple times from law enforcement, citizens, and the public and public servants in the judicial system that the legislature has failed to give them guidance on how this process should be implemented. So that is what we've tried to do with this piece of legislation. What this bill would do is it sets up penalties for custody interference, and it clarifies the process, leaving a little wiggle room for families that are in crisis or unique situations. The process, how it's designed, is similar, what we put in there was similar to Idaho's trespassing laws. And although it's not as aggressive, it has escalating consequences when you violate the law concerning custody interference. It also addresses some of these issues earlier to help give relief to the courts, so not as many issues end up in the courts. What we did was gave guidance to law enforcement on how to deal with these sometimes emotionally charged situations. The last thing I want to mention about this bill before I dig into it is time taken or lost is time returned. So when a parent is deprived of the time that they would have normally spent with their kid because the co-parent won't bring the child back for these exchanges, the deprived parent will get the child back for that amount of time that they had lost. We believe that this bill strikes a balance with all involved in these situations, and it doesn't deny anyone their parental rights. I'm going to dig just a little deeper because I've learned that introduction hearings can sometimes not be clear. I'm just going to go through the sections of the bill real quick so you can look at it and follow along on what it does. So Section 1, we talk about the legislative intent, and the one thing I'll note in there is we wanted, the law was not really clear with custody interference if it was kidnapping the child or not. So we made that clear in the law. We added the graduated penalties in the criminal offense. We just told in this legislative intent exactly what our intent was, clarifying the enforcement duties and keeping parental rights intact. So the very first substance change is actually on page 2, and this is kind of setting up for the penalties. So the first thing we do is, in the past, it was the child was returned within 24 hours. We've changed that to 4 hours now, and so and what we've done is set up, starting on line 11, explanation on what this situation looks like for a first offense, a second offense, a third offense, fourth offense, and fifth offense. Let's see. The next thing we do is we establish a clear law enforcement duties. So within the first 4 hours, what usually happens is you have parents kind of arguing, like, I'm not giving the child over, or you have an abstinent child that refuses to get out of the car and get in with the other parent. That allows law enforcement to come and intervene, and it gives them the authority to be able to intervene in that situation. If the child just doesn't show up, we don't know if that's a kidnapping at that point or what. What it allows the law enforcement to do is verify the child's location, check on the safety and well-being of the child, and just document what they find. That will ensure that the children are safe and that the parents aren't ignored, and that the orders that are given by the courts aren't ignored. And I talked about the penalties already. And let's see, I think there's one last thing. The time taken at the end, what that does is just lets the time to be made up. So we think this bill will strike a balance. We hope you'll give it a full hearing, and with that, I'll turn it back to the committee.
Do we have any questions, Representative? Yes, Representative Pahanka, go ahead. No?
Motion, sir.
Representative Hawkins? I see lights, but nobody wants to talk.
I don't know who you called first.
Well, you're up next.
Thank you, Mr. Chairman, for a motion.
Go
I
ahead.
move that we introduce RS 33038.
Further discussion? Representative Skog.
Yes, Representative Scott, thank you to you and your committee for all the hard work you did over the summer. It was important, and I look forward to this coming forward, being introduced in our committee. I'll make sure my understanding is correct, though. You are introducing this, and we're going to let it set for a while so that people can come forward and give comment about any potential changes. Is that correct?
Absolutely, although I will note that Representative Alfieri was on our committee, and Representative Gannon and Representative Erickson. So we do have a full, I mean, we spent hours in this committee, and this wasn't written lightly. This has been in the making throughout the whole process. We tried to spare the committee all the testimony that we had to hear. So all that testimony, that it was probably 4 or 5 hours every meeting. We had 5 or 6 meetings. And what we did is we created a white paper where you can read a lot of this. It's documented straight from the transcripts. And so I will be happy to share that with the committee. We also did surveys. And so this is not done lightly. We've met with Mr. Spielman from the Supreme Court. We've met with lawyers, we've met with law enforcement, and so we're hoping when this gets printed, then take a good look at it and see what you think, and we can make changes if need be, or we can send it over to the Senate and let them mull on it. So, thank you.
And if I might just take Chair's prerogative and add some to what Representative Scott said. We heard from over 100 different individuals, and one of the most consistent things that came out was that law enforcement and the judiciary did not have the authority to act in certain areas. That the legislature just did not provide enough direction. And what I can see from what's introduced here is this will solve a great number of the problems. So.